Hello everyone, welcome to today's video in today's video we are going to continue our Industrial Dispute Act 1947 part 2. In part 1 we studied evolution and the important definition of the Industrial Dispute Act, that is how the Industrial Dispute Act or the legislations evolved in India and what are the important definition under the Industrial Dispute Act 1947. Today we are going to study very important authorities under the Industrial Dispute Act. Now authorities means the Industrial Dispute Act provides with the settlement machineries and preventive machineries. Settlement machineries means those authorities or those bodies which try to settle the dispute between employee and employer. And this starts from the section number 3. So section number 3 is of works committee. So every industrial establishment which is employing 100 or more workmen on any day in preceding 12 months. So whenever this legislation or this provision becomes applicable from that day, previous to that day in 12 months, if there has been even on one day 100 or more people were working even on one day, so next day suppose it became 98, two people resigned, so once it become applicable it would be applicable. So any industrial establishment employing 100 or more workmen preceding 12 months, the appropriate government will give the general order or the special order. Now, what is general order? What is the special order? Suppose this is the district and these are the number of the industries in particular district. General order says when the order is passed for complete district, that is your general order. Special order says that in this particular district, only for this particular industry or particular part of this industry the order has been passed, that is your special order. So the appropriate government either by the general order or by the special order will ask the employer to constitute the work committee. Now this work committee will have equal number of representatives of employee and the representatives of employer. The employee's representative would be selected from the trade union if there is any trade union in the industry. Now, what is the work of this particular work committee? It settles the dispute and try to maintain the relationship between employee and employer. What are the duties of work committee? That is given under the section 3 clause 2. It talks about promoting the measures, means coming up with those advice, coming up with those steps which will help to maintain the good relationship between employee and employer, to come on the matters of the common interest. So employee and employer, if they are having the dispute, discussing and coming on those matters which are of common interest for both of them, and to achieve any material difference of opinion. So if there is a dispute between both of them, then what is the opinion difference occurring because of which the dispute is there? To find out the reason of the dispute is the duty of the work committee. So first authority under the Industrial Dispute Act. Next important authority or another body is coming under the section number 4, that is the conciliation officer. Now conciliation officer is appointed by the appropriate government. Who? Appropriate government by the notification in official gazette can appoint a conciliation officer. What is the work of conciliation officer? Duty of mediating and promoting the settlement of the industrial dispute. Now this conciliation officer can be for specified area or specified industries, or in a specified area or for one or more specified industry. So he can be for particular one small industry or particular one big industry or region, either permanently or for limited period of the time. So he can be permanent or temporary. Now this conciliation officer would be sending a report of settlement, which is the memorandum signed by both the parties to the government. Even in the failure of the settlement, or even if the failure is not arise, the report of the failure of settlement has to be sent to the government or the supervisor, and all these two reports have to be sent to the government within the 14 days of commencement of the proceeding. So this is the first stage of mediation of the third party, where the third party enters into the dispute of employee and employer and try to resolve the dispute in the friendly way. Now, before we move ahead, let me make you understand the complete process. Let's take an example that this is an employee and this is an employer. So now the employee and the employer are having the dispute. So first way of resolving their dispute is by their mutual way or mutual understanding through the collective bargaining. So in the collective bargaining, by their mutual negotiation, by their mutual discussion, by their mutual debates, and number of the things, mutual understanding, they would come to an agreement that both of them are agreeing on something. So they would be coming on agreement. Now suppose the collective bargaining is not successful, then the mediation occurs. Mediation in Indian legislative term is called as conciliation. So under the conciliation process, so first way of the mediation is the conciliation process. Now under conciliation process, the first one is your conciliation officer. Conciliation officer is appointed by the appropriate government, which we studied just now. So this conciliation officer will try to resolve the dispute between the employee and the employer by the amicable or the friendly way. So by their mutual understanding, he would just mediate, he would just advise, and he would try to bring the settlement. Even in the failure, he would report. So he would try, he would just advise that both the employee and employer come to certain agreement. And the output of this conciliation officers efforts or conciliation process here is settlement. They come on the settlement and it is called as memorandum, which is signed by both of the party. Now suppose the conciliation officer is not able to resolve the dispute, then comes your board of conciliation, which is again appointed by the appropriate government. It consists of the chairman and 2 or 4 members. These members are having equal representatives of employee and employer. Again, the board of conciliation will try to resolve the conflict between the employee and the employer by the friendly way. So again, they are advisory in nature, they won't impose. So they would again come to a settlement. So again, here there would be a memorandum which would be signed by both the parties. Now next comes your court of inquiry. This is not the settlement but a fact finding machinery. So appropriate government will appoint or constitute the court of inquiry to find out the fact, reasons why the dispute has occurred. Then comes the next step of the arbitration, which is given under the section 10 of the our industrial dispute. Now this arbitration can be of two types. One is your voluntary arbitration, one is your compulsory arbitration. Compulsory arbitration is called as adjudication also, because here whatever the final thing or interim or final award comes, it is binding on both of them, and it is the last method of resolving the dispute. Now arbitration can be of two types, voluntary and compulsory. Under the voluntary arbitration, employee and the employer approaches the third party or called as the arbitrator. Here the award or the output of their understanding, or rather you would say the output of this settlement, is called as the consent award. Why it is called as the consent award? Because the person here is the arbitrator and he will try to bring them to the settlement, and his award would be binding. So though they are voluntarily approaching the arbitrator, they are trying to resolve in the dispute by themselves, but finally the award is to be binding, and hence it is called as the consent award. Whereas in compulsory adjudication process or compulsory arbitration process, we have the three ways: labor court, industrial tribunal, and national tribunal. All of three has got the presiding officer here, here, and here. So now if suppose the dispute has not been resolved in any of this way, finally the compulsory arbitration or the government, so appropriate government refers the dispute to the labor court, appropriate government refers the dispute to the industrial tribunal, and central government refers the dispute to national tribunal. And finally all three, for three, here the final output or final determination or the interim is the award, which is binding on both the parties. They have to agree anyhow. So this is the complete process of the settlement machinery in India. So we did conciliation officer. Now let's move to the question: which of the permanent settlement machinery has been mentioned in the act accountable for speedy and amicable settlement of dispute? So it is conciliation. So it is permanent, speedy, and amicable. So it is conciliation. Next comes here section number 5, board of conciliation. Once the conciliation officer is not able to resolve the dispute, the appropriate government constitutes the board of conciliation for promoting the settlement of dispute. Now this board would consist of a chairman who would be an independent person and 2 or 4 members, where every member, 2 or 4, there would be equal number of representative from employee and employer. So if there are 2 members, 1 each. If there are 2, 2:2 is the ratio. So chairman is the independent person. Now if the party, so there has to be 1 representative from employee, 1 has to be from employer. Here 2 from employee, 2 has to be from employer. Now suppose either the employee or the employee is not able to decide that who would be representative from their side, and employer is not able to decide who would be the representative from their side, then the government shall appoint such person as it thinks fit to represent their part. Now, the board will work in an prescribed quorum, and it cannot work in absence of the chairman. So, if the position of the chairman is vacant, the proceedings wouldn't take place. But in case appropriate government has already declared, already notified that for certain period of the time the position of the chairman would be vacant, अगर appropriate government ने पहले ही declare कर दिया कि नहीं अभी कुछ time के लिए chairman की जरूरत नहीं है, in that case the proceedings can take place. Otherwise, the board shall not act until the new chairman or the member, as case may be, has been appointed. So, this is your board of conciliation. Next comes your section number 6, that is your court of inquiry. Again, the appropriate government can constitute court of inquiry for any matter connected with a relevant of industrial dispute. So this is a fact finding machinery, inquiry. It inquires into the matter. Court of inquiry will have one independent person as a chairman, and it would consist of 2 or more persons. One of these 2 or more persons would be appointed as a chairman. Again the same thing, the court would be working in a prescribed quorum, and it won't be working in absence of the chairman or any of its member. But if the appropriate government has already notified that the services of the chairman has been ceased for the certain period of the time, then proceeding can take place. Otherwise, until the court shall have the new chairman, the proceeding won't, or you can say the inquiry won't be taking place. So that is your section number 6. Section number 7 comes your adjudication, which is the ultimate way of resolving the dispute. Under adjudication, we have labor court, industrial tribunal, national tribunal. So labor court is again constituted by the appropriate government, can constitute one or more labor court for the adjudication of industrial dispute relating to the matter specified in the second schedule. Now under the Industrial Dispute Act, we have 5 schedule: 1, 2, 3, 4 and your 5. One is your public utility services. Second is your matters relating to labor court. Third is your matters relating to industrial tribunal. Fourth is your notice to change. And fifth is your unfair labor practices. So 5 schedule, we will be studying them one by one. But please remember, second schedule gives the matters, list of the matters with which the labor court would be dealing. So now this labor court shall consist of the one person only, and he would be appointed by the appropriate government. That person is called as the presiding officer. So labor court mein there would be only one person, and he would be called as presiding officer, who would be appointed by appropriate government. What all qualifications are required to be a presiding officer? So he should be a judge of high court, or having 3 years experience of district judge or the additional district judge, held any additional judicial office for 7 years, presiding officer for the labor court constituted under the act of 5 years, deputy chief labor commissioner central or the joint commissioner for the state labor department having 7 years of experience, or as a conciliation officer, officer of the Indian legal service in the grade of 3 for 3 years, chairman or any other member of the labor appellate tribunal for 2 years. So these all qualifications are required for the labor court's presiding officer. Next is your section number 7A, that is the tribunal which is the industrial tribunal. Just industrial tribunals which is at the state level. Now after the labor court, the matters which are related to second and the third schedules are dealt with the industrial tribunal. Now how? We will be discussing that. First thing, the appropriate government constitutes one or more industrial tribunal for adjudication of industrial dispute relating to the matter which are specified in second and the third schedule. So second schedule matters are to be dealt by labor court, but any of the matter which is hampering or get affecting 100 or more people, if it is 99, it would be taken up by the labor court. If it is 100 or more, it would go to the industrial tribunal. So second as well as the third schedule. Now tribunal will also be consisting only of one or more person to be appointed as a presiding officer. Qualification are exactly same to that of the labor court, judge of high court, district of judge, additional judge for not less than 3 years, deputy chief labor commissioner, joint commissioner of the state labor department having degree of law or the experience of 7 years in labor department, 3 years experience as a conciliation officer, provided they would be resigning. They cannot be into the central government, so they have to resign from their service. And he is an officer of the Indian Legal Service grade 3 of with the 3 years of experience in the grade. So these are the qualification for presiding officer in the tribunal state level. So these are the second schedule matter, third schedule matter. So labor court, if it is related to property and legality, it is affecting 99 people, it would be taken up by the labor court. And if it is affecting 100 or 120 or 100 or more people, it would be taken up by the industrial tribunal. So second as well as the third schedule matters are dealt by the industrial tribunal. Please by heart this also, because in exam the questions appear that which are the matter which are dealt by the industrial tribunal or the labor court. Next comes your national tribunal. Now here comes the central government. all of the things, court of inquiry, board of conciliation, and everything is appointed by the, constituted by the appropriate government. But here comes the central government. So central government will constitute one or more national industrial tribunal for the adjudication of the disputes which involve the question of national importance. Means those dispute which are affecting more than one state, national importance के हैं. So establishment situated in more than one state or likely to be interested or affected by such dispute. Again, it would be consisting of only one person who would be appointed by the central government, called as the presiding officer. He can have the experience only of the judge of high court. So only a person having the experience of judge of high court can be appointed as presiding officer of national tribunal. Two-person as an assessor can be appointed to advise the national tribunal in the proceeding. Other than the presiding officer, there can be two or more person as an assessor. Very important section now here is disqualification of presiding officer. If the person presiding officer is not independent, means if he belongs to either employee or the employer side, if he is not independent, then he would be disqualified. If he has not attended, if he has attended, means he has crossed the 65 years of the age, he would be disqualified. So this is important. Questions are asked in exam. Now, qualification, terms and condition and services of presiding officer. Qualification are exactly which are given in your labor court, industrial tribunal and national tribunal. Presiding officers terms and conditions are given by the in a prescribed format under this law. Section number 8 says filling of vacancies. This says, suppose there is a vacancy in court of inquiry and the board of conciliation for the chairman. So this would be filled up by the appropriate government. If it is the labor court, industrial tribunal, national tribunal, here the presiding officer's vacancy is there. It would be filled by the appropriate government. Here again appropriate government. In national tribunal, it would be by the central government would be making a decision. So they would be making an appointment. So this is what the filling of vacancies is. I am not reading it completely because I have explained you what it is. Finality of order constituting the boards. Now what is finality of the order? Now suppose any of the order which is given by the appropriate government or the central government regarding the appointment of the chairman or the presiding officer of the court, tribunal or national tribunal, they won't be questioned in any manner. No act or no proceedings carried out with this court by the board or any of the proceeding before this court will be questioned just because if there has been vacancy. No settlement which has been arrived out of this board or the court, or any of the award which has arrived out of the labor court or the industrial tribunal, no question would be asked upon, or it cannot be appealed. It would be considered as the finality. They are considered as the final. Next important section is section number 9A, notice of the change. Very important. So now under the fourth schedule, there are the matters like working hours, like holidays, spread over, intervals. So these all are related to terms and conditions of the employment of the worker. Now suppose employer, the working hour starts from 8 a.m. to 5 p.m. Now employer wants to change this. So employees who are going to get affected from this change have to be notified. So employer, before making the changes, have to notify the employee that I am changing your working hours. So how much days? Within 21 days of such change. So no employer shall make any change in service applicable on any workman in any other matter in fourth schedule without giving a workman notice of change in a prescribed manner or nature proposed to be affected within 21 days of change. Now, but here is the condition that if the labor court award has come or by some settlement, that is by board of conciliation or conciliation officer, through them If any changes are coming related to the working conditions, those does not require to give the notice, because they are the settlement, they are the award, they are anyways need to be brought about in the operations. So provided no notice shall be required for affecting any such change where the change is affected in pursuance of settlement or award. Section number 9B says power to exempt. This says appropriate government, if want to exempt any industry from the provisions of the section 9A, it can do it. So who is having the power? Appropriate government, by giving an official notice in the official gazette, can exempt. Next important chapter 2B talks about grievance settlement authorities. We studied the important authorities under this law. Now we have the grievance settlement authorities or the committee. Section number 9C talks about setting up or formation of the grievance settlement authority or the committee. This was added by the Industrial Dispute Amendment Act 210. So 2010. Now what does this say? That every industrial establishment which is having 20 or more workmen can appoint one or more grievance redressal committee. The work of the grievance redressal committee is to settle the grievances, remove the grievances. So the grievance redressal committee would be constituted in every industrial establishment where 20 or more workmen has been working. It would consist of equal number of representatives of employee and employer. The maximum total number of members should not exceed 6. That is, the maximum is 6, and one member has to be woman. Now, chairman has to be appointed alternatively from the employer side and the employee side. 1 year from the employer, 1 year from the employee, alternatively. इस साल employee के side से, अगले साल employer के side से. Now, whenever the dispute or grievance reaches this committee, the committee has to complete its proceeding within the 30 days on receipt of the written application on behalf. So, the day on which the application have reached this committee, from that particular day, within 30 days, the committee has to complete its proceeding. Now, suppose as in workman, I made an application to the committee did a settlement and gave me the final thing, but I was not happy. So I can as a workman appeal to an employer against the grievance redressal committee. So employer को हम अपील कर सकते हैं. Now employer within 1 month from the date of such appeal dispose of, या तो वो dispose करेगा या remove करेगा या नया decision देगा. So it would be given within 1 month. But the provisions are not applicable to all these provisions are not applicable to those establishment which is having already established grievance redressal mechanism. It is already having, so why to apply again? So it won't be applicable. So this is grievance redressal committee. It would be formed in every industrial establishment employing 20 or more workmen. One or more grievance redressal committee can be formed having equal number of members of employee and employer. Total number cannot exceed 5. One has to be woman. Chairperson selected alternatively from employer or employee. Proceeding has to be completed within 30 days. Workman can appeal to employer. Within 1 month, employer will dispose the same, send a office decision. Then comes your reference of the dispute to the board, court or tribunal. Now, the Board of Conciliation, Court of Inquiry, Labour Court, Industrial Tribunal, National Tribunal, they do not start mediating or they do not start working on the dispute by themselves. The dispute is referred to them by the appropriate government. So the appropriate government in writing refer the industrial dispute which is existing or apprehended, which is supposed to be. So this industrial dispute is referred to the board. Board means the Board of Conciliation or the Court of Inquiry. It would be referred to the Court of Labour Court if the matters are related to second schedule and if it is not affecting 100 or more workmen. It would be referred to tribunal if it is the matter related to second or third, and it would be referred by the central government to the industrial to the national importance to the national tribunal. So this is the reference. They don't start settling by themselves. The disputes are referred. Section number 10A, very important, which talks about voluntary reference, which is nothing but your provision for voluntary arbitration. Now, what is this? Now, suppose there is an industrial dispute which is existing between the employer and the workman. And if both of them are agreeing that they would be approaching the third party called as an arbitrator, they can refer their dispute to the arbitrator. But this reference has to be made before the appropriate government make any reference to labor court, industrial tribunal or national tribunal. So, can refer the dispute to the arbitration before referred under the section number 10. Arbitration agreement is signed by both the parties. Now, whatever they are coming out with, that is called as the consent award. So, arbitrator gives the award which is signed by both the parties and it is binding. The copy is forwarded to the appropriate government conciliation officer. Within 1 month, as soon as the appropriate government receives the copy, it will publish in the official gazette. So, very important provision, voluntary arbitration. Then comes your procedure, powers and duties of authorities. So procedure power, what kind of procedure or powers the member of the board or the conciliation officer have? They can enter into any industrial premises after giving the notice and ask for any document. Every board, every court can enforce the attendance, can ask for any person to come, compel any document to be presented. Any court, labor court, tribunal or national tribunal can appoint one or more assessor. Now, every board, court, labor court, tribunal and national tribunal has the same power as that of the civil court. What all powers? They can enforce the attendance for person examining him for oath, shapat leke sach bole, can examine, can ask anyone to do so, compelling the production, documents ask कर सकते हैं, issue the commissioning for the examination of witness, witness को बुलाने के लिए time दे सकते हैं, in respect of any such other matter. And whatever inquiry and investigation is taking place during this particular court, labor court, tribunal or national tribunal, it is considered to be an judicial proceeding under the Indian Penal Code. Section number 12 talks about duties of conciliation officer. As soon as the dispute is received by the conciliation officer, he would hold the conciliation proceedings in a prescribed manner related to the disputes which are related to the public utility services. So as soon as the dispute reaches, he would investigate all the matters and would try to bring the settlement, will try to resolve the dispute and bring the settlement. As soon as the settlement arises, the report and the memorandum has to be signed by both the parties and sent to the appropriate government. Even if no such settlement is arrived, it is the failure. In that case also he would close the investigation and send a complete report to the appropriate government stating what were the steps taken by him and what were the facts and circumstances relating to that particular dispute, and he has to send this reports within 14 days. Within 14 days he has to send the report. Very important point. Section number 13, duties of the board. So now this is board of conciliation. Once the conciliation officer is not able to resolve the conflict or the dispute, the board of conciliation is appointed and the dispute is referred to it. So without any delay, it would start investigating and will try to bring the settlement. Once the settlement is brought, the report would be sent to the appropriate government with the memorandum signed by both the parties. If there is no settlement arrived, it would close the investigation and send the report, and government, appropriate government shall convey to employee and employer whatever the report has come, failure or the successful. In case if it is successful, it would communicate. If it is the failure and if it is not referred for further labor court, it would convey it to employee and employer. Who? Appropriate government. And the report has to be sent by the Board of Conciliation to the government within the 2 months. How many? Within 2 months. So this is the duties of the board. Duties of court. Now this is the court of inquiry, which is the fact finding. As soon as the dispute arises or comes with the court of inquiry, it would inquire into the matter and send the report to the appropriate government within the period of 6 months. Section number 17, duties of the Labour Court, Tribunal and National Tribunal. Labour Court, as referred by appropriate government, will send the report to appropriate government. Tribunal will send the award to the appropriate government. National Tribunal will send the award to the central government. Copy. Now section number 16 talks about form or the report or form of report or award. So whatever the report comes for the settlement under the conciliation proceeding or for the court of inquiry, this report has to be signed by conciliation officer, member of the board and the members of the court of inquiry. So in writing, the report has to be in writing, signed by all the members of the board or the court. And if it is the award, the Labour Court, Tribunal or National Tribunal shall be in writing and shall be signed by the presiding officer. Then comes your section number 17, publication of reports and award. Once the reports and award reaches the appropriate government or the central government, in case of the national report or national tribunal, the appropriate government within the 30 days, as soon as it receives the report, it would publish an official gazette in a prescribed manner. So this was the class for the day, important authorities. We would be moving to next session in next video. Thank you so much. I hope you liked it. Thank you.